Coming to the last part of my discussion is post-arbitration. Once the award is published, what we should do? There could be two situations. One is when Union of India has won the case, then we need to enforce the award. In Arbitration Act 1940, the award needs to be made rule of the court. But Arbitration Act, Conciliation Act 1996, such requirement has been done away with. Now there is no requirement to make the award as rule of the court. It automatically becomes the rule of the court. We only need to execute it. We only need to enforce it. The enforcement of award is covered under section 36, which is enforceability of award. To implement or to execute or to enforce the award under section 36, we need to file execution decree in district and session court and pray for the disclosure and attachment of the asset of the party. This execution decree will be as per the CPC, Civil Procedure Code. The second situation is if the Union of India has lost or we want to challenge the award. Now, unlike the earlier situation, the jurisprudence in India with respect to the arbitration award has evolved in the recent times. Now, the situation is that courts cannot modify the award. They cannot absolutely modify the award. Even section 34 of Arbitration Act says that the prayer to set aside the award. Court has got only the power to either enforce it or to set aside the award. It cannot modify the award. By modify, I mean to say that, let's say there is a claim and a certain claim has been passed by the tribunal and the claimant contractor wants to increase the amount of the claim, it cannot be done. Let's say the interest of 12% has been passed by the tribunal and Union of India wants to reduce it to 6%, 7%, then it cannot be done. Modification of award is absolutely not permissible presently. As the jurisdiction we stand today, there have been recent judgment, NHAI, Reliance cases where the Supreme Court has said that court should not interfere with the arbitral awards. They can only set aside, and the grounds to set aside the arbitral award under section 34 are very, very narrow and very limited. Very narrow and limited are such that number one ground is, as I said, party is not adequately represented, party was under some incapacity, and that is why I said that it is very important to establish the identity of the party. Section 34 gives this liberty to the party where it can say that it was not adequately represented, it was under some incapacity and the award can be set aside. So, if we win the case, the fruits of the award cannot be taken. Second ground is the ground of patent illegality. For example, against the award if published on the basis of no evidence or the vital evidence has been ignored, then it becomes the ground of patent illegality. There are certain others, so the ground of patent illegality is there. Third is the ground of the award going against the public policy of India. Now, what are the grounds for the public policy? Public policy is, for example, corruption. Second is the award going against the statutory law, the laws of the law of the land, the basic morality and the concept of justice. If the award goes against the basic tenets of morality and justice, it can be set aside. So, these are 3-4 very, very limited and narrow grounds, and for all practical purposes, Supreme Court of India has now come up with the argument of plausible interpretation of the arbitral awards, where it gives a huge latitude and a huge degree of freedom to the arbitral awards. They can be interpreted in wide sense, and the Supreme Court of India says that if the award can be interpreted in any of the plausible ways, then it should not be set aside. And it is actually a welcome step, so that the awards can be enforced and the burden of litigation does not pass on to the courts. So, it is a welcome step indeed. The important point, however, is that the doctrine of severability can be applied against certain claims of the award. What is doctrine of severability? Let's say there are certain claims to which we do not agree, then we can pray to the court to remove these claims and they can be sent back for the arbitration. But in nutshell, the awards can only be set aside or can be implemented. If the award is set aside, then the only option is to refer back to the arbitration. If the parties agree, then the court can allow the matter to be referred back to the same bench, same tribunal, or a new tribunal can be formulated. Thank you very much for listening to my discussion on the topic of arbitration. I hope it will help you all in successfully defending the cases on behalf of Union of India, so that we can save precious money of exchequer. Thank you and Jai Hind.